This is Renee Miller. She's the county attorney for Washington County, and she represents CPS as their attorney in all of our Washington County cases, in addition to some of her other duties. So tonight she's going to kind of be talking about the courtroom, testifying, do's and don'ts, how CASA can be helpful, maybe some things not to do.
In front of a judge.
In front of a judge,
What not to say.
relationships, working with each other and helping each other out. So we'll go from there.
Are all of these folks going to be volunteers in Washington County?
Not necessarily.
Not necessarily. Okay.
Wherever we
Okay.
have a need.
Okay, all right. Well, first let me give you my card, in case something should come up and you have any questions, just take one. I first want to talk about the role of each person in the courtroom. And I can really only tell you how it happens in Washington County. The roles are always the same, but as far as how our procedures are and how things happen. First off, there is Child Protective Services, and that's my job as the county attorney here in Washington County to represent the Child Protective Services and what they are wanting to do, what they're wanting to accomplish in a particular case. If you are assigned a case in other counties, you may not be dealing with the county attorney, because across the state of Texas, each county is set up by 3 different models. There are some places that have a county attorney and a district attorney, kind of like what we have here in Washington County. And in Washington County, the district attorney handles adult felonies only. But the district attorney does have 2 counties, Washington and Burleson. And then my job as county attorney is basically everything else. And if you're not familiar with what the court system is, everything else would be adult misdemeanors. We prosecute juveniles. We represent the petitioner in a protective order case. We represent Child Protective Services in CPS cases. We are also the legal advisors for the Commissioner's Court, and then juveniles. We also represent the state in juvenile prosecution, and that's if the juvenile commits an adult or a felony. So, but in other counties, you may have a criminal district attorney, and that district attorney's office does all of the criminal work, and then you may have a county attorney that does the civil work, which means they may do the Child Protective Service cases. Then again, they may not. They may just be the advisors to the Commissioner's Court, and the criminal district attorney would pick that up. Okay, or you can have a county attorney with felony jurisdiction, which would mean that they would then handle all of the cases, the criminal prosecution, as well as CPS, as well as protective orders. It just kind of, each county is a little bit different, so you just kind of have to know where you're going as to who it's gonna be. But if they're there protecting CPS, probably the case is going to be just handled about the same. Also, then you will have your attorney ad litems, and the child is automatically appointed an attorney ad litem. Okay, and what that person does is that person represents what the child wants. Okay, and when it's a younger child, probably the child may not be able to communicate, or maybe the child is of an age where the child can communicate, but maybe the child really doesn't know exactly, what they want. They like their placement, they like mom, they like dad, that type of situation. But as the children get older, there is then definitely a difference between what the child wants and sometimes what's in the best interest of the child. Okay? And so the attorney ad litem represents what the child wants, whereas you, as CASA volunteers, are the guardians ad litem, and you represent what's best interest for the child. Okay? Sometimes it may not be what the child wants, but you are there to represent to the court what's the best interest for that child. The parents don't always get an attorney ad litem. However, if we know that there are mental impairments that are documented by mental health authorities, then that parent will automatically get an attorney ad litem. Otherwise, they will have to request an attorney from the court. They will have to fill out an application for court-appointed counsel, and if they qualify, they will get an attorney And then that attorney will be called attorney ad litem.
What does that attorney do for the
parent.
parent?
For the parent, they advocate what the parent wants.
Okay, so I would imagine that in every case, the parent will want their kid to live. Well, no, that's
Not always.
Not
Yeah,
every case.
that's not true.
Right.
Yeah. Okay.
Okay. And they can always hire their own lawyer if they have one. And if they can afford one, they can always hire a lawyer. And then the role of the judge is strictly to determine what is in the best interest of the child, where the child should be placed, so that the child is not in danger and that the best interest of the child is served through his decision. And then there are you all, the CASA volunteers. And I said, you're the guardian ad litem for the child, and you're there to advocate for what is the best interest for the child. And when we go in front for a hearing in Washington County, we are all going to, it's a very small courtroom. We just have one table as counsel table. So we all usually stand between the table and the bench. And we stand there in a big semicircle and we identify ourselves to the court. That's the first thing we do for the court reporter. And one thing that you have to keep in mind, in Washington County, I said it's a small courtroom, so it's not very intimidating. But some of these larger courtrooms, it's kind of intimidating, and there's a lot of people. Just as sometimes our courtroom is packed too, and there's a lot of people. But you should not be intimidated, okay? You have a role, you're supposed to be there, and we need to hear from you. So when that case is called, because each case will get a cause number, when that case is called, you come on up to the front too, okay? Don't sit back there in the back. You come on up to the front, all right? And when we go around and we identify ourselves, mine is always, I'm Renee Miller, I'm the county attorney representing CPS, okay? And there'll be a CPS person, there'll be the attorneys ad litem, if they, for the child for sure, but then maybe for the parents will be there, and then CASA will be there, and we need for you to identify yourself, just your name and CASA volunteer for this case, okay?
And we also announce that you're guardian ad litem for the child on the
Yes.
record.
Mhm.
Oh, okay.
So,
Name, guardian ad litem.
right. And basically what happens then at the hearing is there are different hearings, and I'll go over that with you with the handout that I have for you. But basically at these informal hearings where we're standing in front of the bench, everything still needs to be taken down by the court reporter. So we can't speak on top of each other. Usually the judge looks at me and I go first. And I call the caseworker for CPS. And depending on what kind of hearing it is, if it's a very early on hearing, what we call a status hearing, then we are going to be asking questions of the parents too. But otherwise, we just get the CPS caseworker to give the court an update of what's been happening, what the parents have been doing, what the parents have not been doing. Has there been something unusual happen, like maybe the parents got arrested, between now and the last time, things like that happen. Or the parents move, or something has happened with the child, maybe the child is not happy where they're at. We just give the court an update of what has happened. And then the court, after hearing all of that from us, the attorney ad litem for the child will get an opportunity to ask questions of the CPS caseworker. And also then if there's an attorney for a parent, they can ask questions of the CPS caseworker too, okay? After that, any other party can call witnesses if they want to. Sometimes most of the time that does not happen, okay? It's just kind of a CPS thing. But after all of that is said and done, then CASA is asked for their opinion, okay? As to how, because I'm sure that Joe will tell you, but you will be meeting with that child regularly. You might even be meeting with the parents too, to see what's going on in their lives. And that's your opportunity to tell the court what you've been doing, how things have been going, that kind of thing. If you have any concerns, that's the time too, to say, we have concerns about this, this, and this, or, we have concerns. And it could be concerns like maybe parent isn't doing what they're supposed to. You know, we have concerns about the home. We have concerns that CPS isn't getting the services to the people, to the parents. It could be any number of things, okay? Because you're not on anybody's side, okay? You're not on CPS's side. You're not on the side of the parent. You're there to represent the best interest of the child, okay? So, you know, you may feel that, oh, the parent is such a good person, you know, they're trying really hard. Well, that's wonderful, but they need to try hard to get things done so that their home is a good environment. You know, they have steady employment if that's what they need, whatever the plan does. Now, there are meetings too that are not the hearings, and those are family group conferences. There's your CASA updates where you meet with people, and those are handled either at the CPS office. I don't know if you meet any of them here. Or,
Only if the CPS office is not available.
okay. So those are also meetings where you can really get a good feel for what's going on too. And, you know, sometimes that's probably sometimes the only time you can talk to the parents, because sometimes it's hard to track those people down, you know. But anyway, that kind of gives you an idea of the hearings. The next thing I want to do is I have a handout for you, and this kind of gives you an idea of how these hearings work and what kind of order that we have them in. And it says overview of the new 12-month court process for child abuse and neglect cases. Well, it's not so new. It's not so, but the booklet I was using was published right after it came out. So, but basically that title tells you that we've got 12 months from the date that Child Protective Services takes that child into custody. We've got 12 months to reach a resolution on this case, okay? So the first thing that we're going to do is we would file this emergency hearing ex parte temporary managing conservatorship orders. And it's called a SAPSER case. It's a suit affecting the parent-child relationship. That's what that SAPCR, suit affecting parent-child relationship, okay? And we file that, and that is accompanied with an affidavit from Child Protective Services outlining why the child is either in a harmful environment, or either the child is being neglected, or the child has been abused, something along those lines. That's what's outlined in our affidavit. And with that is a request for an attorney ad litem for the child and a request for the guardian ad litem. So right there in the very beginning, we are requesting CASA to be participating in this case. And within 14 days of filing that, you see the little arrow comes down, it's a 14-day adversary hearing. And that's a pretty heated hearing. But if it's all possible for you, if you already know that you've been assigned to this case, come to that adversary hearing, because you will learn a lot about your case, okay?
So the first field we want to be there, because that's...
The emergency
No.
part, no. And an ex parte means without the other party being represented.
Gotcha.
And because it's ex parte, it's something we just initiate without them having a hearing. That's why we have to have the hearing within 14 days.
If-
Go
sorry.
ahead.
After the 14th, when you have the adversary hearing, is
Mm-hmm.
that's something that's scheduled and you know when it's going to happen?
Yes,
Yes.
when we file those temporary ex parte papers, we are given a date. And then the parents are served with those papers and they have that date.
Okay, so then we would know.
Yes.
Yes.
When you're assigned the case, you'll know the next court date.
Okay, yeah.
We try to assign our volunteers before the adversary hearing. It's not always possible, depending on how quickly we get the case,
Right.
how quickly we can get a hold of you guys and match you up and get out there to visit. So we try to, because again, at the adversary hearing, a lot of the relatives come out of the woodwork at that first hearing.
Yes.
And it's sometimes the only time you're going to see the parents throughout the case. Sometimes they just come to the first hearing and then you never see them again.
Right.
So
If they don't show up to the first hearing, what happens to
a
them?
default.
So then you do with the kids what you feel like you need to do?
CPS then
Because
gets
if
a
they-
temporary managing conservatorship of the children through default.
Okay.
If you need to be a court, you gotta be there.
Well,
In
yeah,
any case.
I understand that, but
Yeah,
I'm
no,
just saying,
Yeah.
like, I mean,
Right.
I would imagine that these people, if they're that messed up, they could possibly miss that hearing.
Sure, sure.
Yeah.
And then we would have to show that they received notice and they chose not to come.
Yeah.
If we can't show that they were given notice of this, then the judge may continue it until we can get them noticed and served of it. So, but anyway, so at that hearing, there are things that Child Protective Services has to prove, and so we put on evidence to prove that. And this is a civil proceeding, and so it's not a beyond a reasonable doubt burden, and it's not even a clear and convincing. It's a little bit less than clear and convincing burden of proof. And excuse me, and then the judge has to decide whether we've met our burden, whether the child, whether we can show whether the child is in danger, or whether the child has been neglected, and whether there's a continuing danger for the child to be in that home. And also the judge also looks at whether we've done everything we can to find other alternative placements other than Child Protective Services taking custody of those children. So Child Protective Services is in communication with that parent that they took that child away from because they want to try to find relative placements, or what they call kinship placements. So if we prevail at that adversary hearing, first off, if we don't prevail, then the child is going back home, okay, to whatever environment we didn't think that we didn't like to begin with. They're going back into that environment, okay? So, but if we do prevail, then we have temporary managing conservatorship. That's what that TMC stands for. And from 60 days from the date that we have that temporary managing conservatorship, we have to have what is called a status hearing, okay? And the status hearing is going to be conducted in that informal semicircle in Washington County, okay? And while we're waiting for that 60-day, or within 60 days for that status hearing, what is happening is Child Protective Services will have a family group conference with the mom and the dad, if they're there, any other relatives that are involved, and they will talk about the needs of the parent based upon what they found, based upon why they removed it. And all of that will be put into a document called a family service plan, okay? And this family service plan will outline what each parent has to do. And what when we say have to do, this is what we feel that they were lacking in, okay? Maybe they didn't have a clean home. Maybe they have an alcohol problem and we think they need to address that. Maybe they have a drug problem, we think they need to address that. Maybe they weren't providing adequate supervision for the child and they need to address that. Things along those lines. It's a plan that they need to follow, okay? So that happens within 45 days of the adversary hearing. And so then within 60 days of the adversary hearing, we have to have the status hearing. And at that status hearing, it's going to be a little bit longer because we're going to review these family service plans with each parent. So it's put on the record that they understand exactly what they need to do, okay? Because basically at this point, unless there's just really something terrible happening, CPS is going to want to try to reunite this family, okay? And so that's why we want them to take some classes or do some things in the areas that we felt they were lacking. And that family service plan outlines what they need to do. And so we will have them testify that they've looked at this family service plan, that they understand it, they agree that this is something they can accomplish and that they're going to try to do that, okay? There'll also be other testimony from Child Protective Services about where the child is placed, how the child is doing, are the medical needs being provided for, are there any special needs that the child has that need to be addressed. All of those things will too be brought forward. The attorney ad litem for the child hopefully will have visited with the child and they can give us a report on how the child is doing too. then within 180 days, and usually it's sooner than that, we have initial permanency hearing. And this here, we're just, again, touching base, see how the parents are doing with their plan, see if they're working their services, are they having any trouble, how the child is doing in the placement that the child is in, or is it not working out, do we need to try to find a different placement, things like that. We're just trying to keep everybody apprised of the situation. More particularly, we're trying to keep the court apprised of the situation, because CPS and the attorneys at LIDM usually will know if there's a problem right away. Because if it's an attorney, if it's a parent, they're complaining to their attorney if they have one, or they're complaining to CPS, and CPS is trying to work on that. The case is not just sitting dormant. Just because we're not doing something in court doesn't mean that other people aren't working on the case. And you all aren't going out and visiting the family, seeing how things are doing, and you can be communicating your concerns to Child Protective Services and things like that. Then we do have subsequent permanency hearings, and they must be held no later than 120 days after the last one. And so after our initial permanency hearing, then within 120 days we could have subsequent permanency hearings. Sometimes we have them sooner than that if there is something that we want to see addressed. For instance, maybe we feel that the parent needs to get into a substance abuse program, and so the court will say, well, instead of waiting the 120, I'm going to reset it for 60 days because I want to see if the parent is enrolled in that class and what the progress is doing. Also, during that time, if the parent is making progress, then visitation is going to be set up. And normally visitation is set up very, very quickly after that adversary hearing. We don't try to keep the parents away from the children, but we do have supervised visits. And they start off, like an hour, and then they can be, longer, and then they can go into unsupervised, But again, we're all looking out for the welfare of the child. And you all are welcome to go and watch those visits too. They're usually at the CPS office. They usually have one-way glass where you can sit behind and watch the visits. And they're monitored by you, and they're also monitored by a CPS worker, okay? And the attorneys are also welcome to go and watch. Before I had this job, I was appointed as an attorney at LIDM, and I would watch how the mother interacted with the child during the visits and things like that. And it, gave me an idea of whether I thought the mother could provide a safe environment. And in this particular case, it was a very young mother, and whether she was mature enough to handle, the child. She also had some mental issues, and whether those would come into play, So all of those visits like that, if they're supervised, you're able to watch them, especially if they're at the CPS office, because they have it set up where you can watch those visits.
Is that like a good way to assess if they are being a good parent? I mean, because it seems like they would act differently.
Sometimes they do, and sometimes they forget you're there, honestly,
Right.
and you'll be surprised at some of the things that they'll do.
Oh, Lord.
Like this lady, she, the child was taken from her at a very, very young age. The child was less than a year, so probably less than 6 months. And so the way she communicated with the child, the way she, didn't quite know how to fix the bottle, and and just things like that. You can just kind of watch.
Or you can catch them, saying inappropriate things to the child,
Right.
saying, I'm going to get you back no matter what, and that
Right.
could upset the child, and then the foster parent is the one that has to deal with that consequence afterward, and so forth. So,
Is it any way that the CASA, could we find out that the parent is going to a parenting class, any of those classes?
Yes.
Is there any way of
Yes,
they
that's
get
a. Uh-huh.
get a number? a telephone number from that agency or where
Yes.
they're going?
Yes.
They get a certificate at the end.
Yes, whenever they're provided a service plan, they are also told who they can get that service through, and then we can get a release from the parents, allowing us access to those records. From their therapist, from their counselor at the rehab place or whatever. But we do have to have a signed release from the parent. Otherwise, we may just hear about their progress from CPS and not actually have copies of the records. But that's something we can discuss at the monthly staffings with CPS. Even if we don't have a release from the parents to get the actual records, we can get a report from the caseworker how the parents are doing in their services.
And I guess I was asking that question because when I worked in a program that we did parenting classes. And sometimes I know that casework is busy. She has about 35 plus cases.
Sure.
So the parents would come to the classes, but we was like, okay, how do they know the progress? We would have to
Right.
wait for the caseworker to call the program to see and check and see if that parent. Now we had some good CPS workers that would, actually monitor that parent within that 12 months to see if that parent is actually going to a class, but very seldom we would get that CASA. Some we would get, but not that many CASA volunteers would call, because I would have loved to work with some of the CASA volunteers.
Well, for one thing, also if the parent is represented by an attorney, we need that attorney to give permission for the parents to sign that release. Even before we visit with the parent, if they have an attorney, I discuss that with the attorney prior.
Yes. Right. I don't know if you were thinking that you wanted to attend the parenting class with them, but
What happened, I would just give you a quick spiel that we did parent anger management, domestic violence, drug classes, and the whole, we did UAs also. Okay. But we would actually wait until that caseworker called. We did not get in it, and we were for the betterment, for the baby. So what happened, we developed a form for the caseworker to let the caseworker know how many classes that parent attend, and we will submit it to the caseworker before we give it to the parent, okay? But it's just that we never did a CASA person. I would have just loved to have, actually connected with that CASA person, because the caseworker was always sort of, busy, and it looked like that CASA parent, the CASA volunteer would be able to tap into those parents closer. Not saying the CPS wasn't, but that's
Right.
how we kept record of letting everybody know in court, the CPS worker know actually if that parent is actually coming to the.
Well, yeah, because, in a dream world or a CASA volunteer, that would be their only case. We have some rare occasions where we have volunteers working 2 cases, but we try to keep that to a minimum. And I make those our, seasoned volunteers. And like you said, the caseworker may have 30 cases.
Yeah, they have.
Right.
So, yeah.
Right. And I think also to hear encouragement, the parent to hear encouragement from the CASA volunteer, the parent is going to be more receptive, because we've really antagonized them by taking their job. And, even though that's a different CPS department than what they will work with after temporary managing conservatorship is given to Child Protective Services, that still doesn't register with some of them. It's still the big umbrella of CPS. It's still the big bad government, taking their child. So, so I really think that you all play a very, very important role in that you can help them see that what they need to do is in their best interest, but it's also in the best interest of their child, and it's in the best interest of reunifying that family. It's not just some government hoop that they gotta jump through, because that's sometimes the attitude that you receive.
Like I'll do this, and then like right after they'll just go back to whatever they were doing anyways.
Right. Or they just, they think it's just like I said, it's just a hoop that they wanted me to jump through, and they don't really see the benefit or the need.
But it wasn't that many parents that came back. But what happened with that program, we made sure that we connect with somebody other than that parent, because it's like you said, when that parent came to the classes, we were the booger bear. You know, it's like, wow, you ought to just like CPS. No, we here to help that baby. So when they got the trust with us, okay, then they began to relax and they knew that when we give reports, we tell them the truth. We're not, you know, and we wouldn't take their side.
Right.
I mean, if you're still on drugs, you're on drugs.
Right.
And I would have to let the, you know, we would have to let everybody know.
Right.
The
Yeah.
court,
Or
everything.
if you're sleeping through the class.
Yeah, but it wasn't that many that actually repeated. You know, they actually would, you know, the majority would actually do what they were supposed to do
Right.
and get their babies.
And as you see on this little chart, the way within 12 months we have to have this case resolved. And resolved either means the parents have done what they are supposed to do. We feel it's a safe environment for the child. We dismiss, or permanent managing conservatorship or termination, which is what the TPR means, termination of parental rights. Happens, okay? Or we can return to a parent or relative and we can still maintain temporary managing conservatorship, and then we're probably going to have to ask for a 6 months extension so that we can monitor that, if that's the first thing that we're doing. So anyway, but most of our cases are, we try to work very hard to resolve them in 12 months. If something positive is happening and we fall within the guidelines and we can ask for an extension, you see too that it just goes straight to an extension with everything staying the same. If we think the parent just needs a little bit more time to work the program, then we might try to find a way to just get that extra 6 months, and hopefully then we can reunite this family. But anyway, one thing I want to bring to your attention, this, like I said, is a little bit older document, but it's still a good flow chart. When they refer to PRS, that they're referring to Child Protective Services, which is now called Department of Family and Protective Services. So if you want to just put that on there, PRS equals CPS.
Yeah, CPS, DFPS.
Yeah, DFPS.
So it's possible that, do these generally last for an entire year, or is it possible that it could last like 8 months and the parent did such a good job that you just end it at 8 months?
That can happen.
Okay.
Or if we see that the parent is doing a really, really good job, maybe the last 4 months, instead of just dismissing the case altogether, the child lives with the parent. CPS is still involved just to monitor the situation. CASA is still monitoring the situation, just so the parent still has that support, that they're not just thrown out there and with no more support, no more people to rely on.
And part of what CASA would do at that point is, if the child is in school or goes to daycare, you know, talk to those teachers, talk to the daycare, make sure, you know, that they're showing up clean, that they're showing up fed, that they're not having a lot of excessive absences that they weren't while they were in foster care. You know, those kind of things that you're going to be following up with.
So that the parent is maintaining the positive environment for the child. So, and you know, if for some reason the department does not prevail at that 14-day hearing, there is something through Child Protective Services. They have different branches. One is the investigatory branch, and they're the ones that initiate the first suit, okay? And they're the ones that are our witnesses at that adversary hearing. But if temporary managing conservatorship then is given to the department, then we move into the conservatorship unit, okay? And if we get to the point where the parental rights are terminated and we want to try to get that child adopted, then there's an adoptive unit, okay? And there's also kind of in between, there's what's called a monitor and return unit, okay? And sometimes if we don't prevail at that adversary hearing, the child is returned to the parents, but CPS is still involved through that monitor and return unit. But the child is with the parents. CPS is just, like the name says, monitoring the return to make sure that there's not an escalating danger there.
How long do they do that for?
That can be up to 6 months.
Okay.
So, But usually if we've had to do this type of removal, that's not what we're advocating for. We believe that we need to have that temporary managing conservatorship so that we can work with the parents so that they can.
And hold them accountable.
Yes. Yeah. A lot of times, if they're young parents, they need the parenting class. They need to understand, maybe they've never had a parent to see what a parent should be. And so that's what we're trying to do. And sometimes a parent, if it's just a mom or a dad, maybe they don't make a really good choice in a mate, and so sometimes that needs to be brought to their attention that, hey, this mate is not a positive influence on your children, and you're going to have to decide the mate or your children,
That's kind of a CASA responsibility, right, to know what's going on.
Yeah.
Now, this might be a silly question, but like on the 14-day, and then you go into 60-day, as a judge, what do you want from us? What are you, what do you
I'm not
want
the judge, I'm the attorney for
Yeah,
CPS.
I'm sorry, the attorney. What does the judge, because you're in the courthouse.
Right.
What do the judge would want for us? Do we go to school? I mean, is there like a list of things? That way that we're not just kind of, okay, we got this case, but we only did 5 out of 10.
Well,
before
I can
the
tell you the
60.
main thing at the 14-day adversary, because again, we haven't had a lot of time to do a whole lot.
Well, are you talking about between the adversary and the
yes.
status?
Between the
Once I've
adversary-
already been chosen
Oh, okay.
to be the cost on the child, what I want to make sure that I'm set up to go in front of the judge and say, hey, look, I'm got.
We
my
have a
stuff
whole
together.
list of things that you
Okay.
should, a checklist you should be doing.
Okay, good.
Checking with the child's school, finding out if there are any relatives that need to be considered. If so, we need to go to those relatives' homes and check it out. It's not an official home study, but we can give the judge our opinion.
Right, well,
in court.
and if you find, sometimes they're more receptive to talk to you, the parents are. So if you can find out of a relative, you need to let CPS know so that we can see too if that relative has we can do the official home study, but you can certainly visit that relative too and find out, how things are going. Another thing, a question, this is kind of off topic, but as soon as you make contact with them, I would like to know whether they, and this is kind of an odd thing, whether they have any Indian descendants.
Yeah.
Yes,
American Indian.
American Indian. Yeah.
That
Why is that?
well, because aren't there special
They get
there's like
special
special laws
programs.
with
There's the
Yes.
Indian Child Welfare Act.
Right.
Yeah.
Ah.
Right, and because of the fact that you're
That's
not
good
the
to know.
government, the parents may be more open to talk to you about that.
Okay.
And so, because sometimes when CPS gets involved and CPS is taking their child, they shut down on us, okay? So, but maybe you can find that out, because we have to then try to figure out which tribe their descendants came from, and then like Joe said, this Indian Welfare Act comes into play. We have to notify that tribal representative, and sometimes they want to be kept apprised of the situation. Sometimes they want to come down and take over, because the parent with the Indian descendant, they have certain rights that we have to respect.
And
That's good to know.
in that case, no matter what happens, really, doesn't the child usually go back to the
Not,
That's what
I've-
they're pushing for. That's
Because-
what the Indians are pushing for.
Well-
yeah. There's I'll show you something like that you can listen to later that had this like all about that. The case that it was like a little girl, wasn't it? That she was like, she had Native American and then like the mom gave her up for adoption, then the dad.
Yes,
didn't
that was
give
a
it up.
big publicity case.
Yeah,
Yes,
that
a lot
was-
of publicity on that.
Yeah,
Oh, I'd like to know
and
that.
yeah, I'll show you something that you can listen to that talks all about it.
Right.
however,
Kinda sad.
when I first started here, I was shadowing the CASA program in Brazos or Grimes County in Bryan, Texas. And they had a case in court that day that involved the Indian Child Welfare Act. And what it was this set of foster parents had pretty much raised this teenage girl in foster care. Well, she aged out, got pregnant, moved back in with them unofficially because she had, aged out or whatever, left her baby with them, But legally, they didn't have any rights to this child. But they had raised her for several years, and the dad had never wanted anything to do with the baby, evidently. But dad's mother, paternal grandmother, found out there's a child. They did have American Indian heritage, and so she got the tribe involved. And then it was a whole contested hearing. They had the tribe on the phone in the courtroom trying to decide if they were going to come in and take this child out of this only home she'd ever known, or, you know, leave her where she was. And the tribe ended up saying it was in her best interest to stay with the family that had been raising her.
Right.
Because the father had not been the one pursuing. Had it been the father being the one pursuing it, they were going to be more out to step in. But
So is that on the last checklist too? Make sure that they're
Native American.
I believe it is on the checklist.
Okay.
But just so that you know, that's the reason we need to know that.
Okay.
Is because then we need to work on, and CPS is able to help determine, you know, which tribe we have to contact, and there may even be an Indian resource person that we call, and that's handled by CPS. I'm not that involved in it, but I am involved to the point that I've had a case where they wanted to be involved via phone. They were not going to come down from Oklahoma for every hearing, but they wanted to be. We had to have them dialed in on the phone, and so. But you're right. There was a case that received a lot of publicity where the father had not been involved, but the father had Indian heritage, and he was trying to get the child and.
The child had already been given up for adoption legally, and then the biological father took the child, and then they had a whole thing, like a whole back and forth. I think she ended up back with the adoptive.
I think so.
parents,
I think she ended up there.
Yeah,
Mhm.
I'll show you later.
Okay.
You can
But-
listen. It's like a radio.
My
show.
only concern is going into court and not being prepared for these children. You know.
Well, that's why you have the supervisor. So we're there with you, reminding you what you need to be
look
doing.
like a dummy in front of the judge. It's like the last thing you want to do.
But
Silly,
and not as an out for you or anything, but the judge doesn't have your checklist. You know, he's not going to sit there and ask you those questions. And one thing to alleviate any anxiety too is you give a report. You do not get cross-examined. We cannot ask you questions. You just give a report.
Okay.
Okay?
So we can like obviously take notes that we like
Yeah.
write down, just like
Yes,
read off
sure,
that kind of.
sure. You can bring your notes with you. I don't have a problem with that. But again, you are not subject to cross-examination. You just give a report. If we have any questions, we may ask you later, you know, what were your concerns, or where did you come up with this, or what, you know, that concern was based on what, that kind of thing. But in court, on the record, we cannot ask you any questions. We can't argue with you if we don't agree with what you say, anything of that nature. You give your report. Okay?
Good to know.
Yeah. So, but I mean, I would also encourage you that if you have concerns with how CPS is handling this, call them. Call that caseworker up and say, hey, you know, I got, you know, why isn't this being offered, or why isn't this being offered? Or if it is offered and the parent is telling you, well, you know, CPS hasn't called me back, or CPS hasn't given me the thing, call CPS and say, hey, what's going on? You know, because a lot of times, you know, maybe CPS has tried to reach out, but you know how cell numbers are. They get, you know, some people just use those burner phones, and there's no more time on it, so it's useless, you know. So you can certainly be the connection too with keeping that if you find out that the parent no longer has that phone number, pick up the number and pick up the phone, call CPS.
And that's where our monthly staffings with CPS comes in
Yeah.
very handy, because we know at least once a month we're going to sit there across the table from each other and share information with
Right.
each other.
Is it important for us to talk to the attorney at Lyndon as well?
Yes.
And tell them
Yes.
what we know?
Yes.
Well, and sometimes you can, if the child is not placed locally, you can carpool with that attorney at Lyndon to go to visit that child.
We do that often.
That's
Yes.
good. I see. I didn't even think about that.
Mhm.
They have to visit the attorney visits them.
Yes.
Has to visit them.
They're supposed to.
Mhm.
They're supposed to.
Yeah.
And I have to say, most of the attorneys in Washington County do their job, and they do visit the kids.
Right.
Not so much in some of our other counties.
Well, if they're in another county, it'd be hard to carpool anyways, right?
It just depends.
Yeah.
So, but it's you know, and sometimes if it's too far to drive, then CPS will bring the child to you, and they'll set up an appointment, and they'll let everybody know the child will be here at this time, and so you can go and.
They won't do it just for you, but if they're already picking up the child for, say, a parent-child visit, they can notify you and say the child will be in Brenham
Yeah.
on this day at this time if you want to come an hour earlier or stay
Right.
come an hour later after the visit.
But if you wanted to see the child in the foster home environment or the placement environment, then you're probably going to need to travel to wherever that is if it's not locally. But and just because you are not cross-examined, just because you give a report, does not mean that you are not a valuable part of this case and that your input is not appreciated and utilized. Okay, I just don't want you all to feel that you're just just some sort of government mandate that we got to work with. That's not how we view you. That's not how I view you. I was county attorney from 97 to 2000, and CASA was not in existence at that point. And I just really feel that the CPS cases move a whole lot smoother because of your involvement, because you're that bridge for that parent or that child to see that someone else out there cares for me, someone else out there is looking for my best interest, and the parents are seeing that, hey, there's somebody out there that maybe is helping me understand why the big bad government wants me to do these things, and because when you come in and say, well, it's not that unrealistic for you to take a parenting class, then they look and they go, well, hey, this is somebody that's not part of the government telling me that I would benefit. So that sometimes that changes their attitude, and you're not going to be able to work miracles on all of these parents. That's just the bottom line. Sometimes we just can't get through to them. Sometimes it just wasn't the right time for them to be a parent for this particular child. And
Sometimes you do get close to the parents. Sometimes you're really rooting for them, and then they pull the carpet out from under you.
yeah,
And I mean,
and get busted for drugs or
exactly.
Yeah.
And you just, it hurts when you've put a lot of time of your own invested in them and trying to see them recover and do the right thing. It can be frustrating,
I believe it.
but when they do get it right, then it's very rewarding.
Yeah. And if you all ever have any questions, this is just a little overview. The boxes down at the bottom, just kind of ignore them because it doesn't really, yes, to a degree it applies, but I just wanted to give you this so that you understand, because you'll feel that we're coming to court a lot. Our court days are usually on Thursdays, usually Thursday afternoon, and we have a lot of CPS cases set along with uncontested divorces or maybe other contested matters that didn't get through in the morning, maybe protective orders. So, it's we do wait. There are times when we do have to wait our turn. Anyway, you can't bring newspapers into the courtroom, but you could bring a paperback book or other book to read. You have to turn off your cell phones when you come in because we can't have any other noises. And there is one thing I want to tell you. I don't mean this in a disrespectful way to the judge at all, but the judge is Judge Matthew Roy, and he's up for re-election. And so if he does get re-elected, there's something I want to remind you of. Judge Roy uses a hearing aid, okay? But he does read lips. So when you give your report, please speak loud enough for him to hear and slow enough for the court reporter to take it down. And if at all possible, position yourself so that you can see him and he can see you. He does have a court reporter that takes stuff down in what they call real time, which means as she types it in, it gets translated into a computer screen and he can read it. But it's, he does an excellent job of reading lips. An example of that is I was sitting in, waiting for my turn at CPS back when I first did this county attorney gig, and he, it was a woman sitting here and her husband was testifying, and the attorney was concentrating on what the guy was saying that was on the witness stand. Both attorneys were. All of a sudden the judge just says, "Excuse me," and he turns to the woman and he says, "If you don't behave and quit mouthing whatever quit mouthing off to him, I'm going to hold you in contempt." And see, what she was doing is she was just, saying every curse word in the book at this guy, and the attorneys were just concentrating on what they were hearing, but the judge was reading her lips. So he's very good at that. But anyway, but it helps him if make sure that when you testify loud so that he can hear, but also so the court reporter gets it down. But then position yourself, because it gets crowded up there in our little semicircle with a lot of people. So when it's your turn, position yourself up there so that you can, he can see your face. So, like I said, I don't mean that in any disrespect. It's just something that if we do that, the whole court then runs more efficiently.
And that's good for us to know.
Yeah, and every judge is different. Judge Eric Endell, that's right now handling our Waller County cases, he doesn't like it if you stand up when he comes in the room. He's just like, "Oh, sit down," And some other judges will be very offended if you don't stand up when they come in. So, every judge has their own personality and rules they go by. Every courtroom's kind of different. That's why it's good if you can go observe our different counties and see how different they kind of are.
And one thing, we at this point still have 4 entrances to the courtroom, but you are wanded through a metal detector before you can walk into the courtroom. So if you can minimize things that would cause the metal detector to go off.
No bling jeans.
Right, yeah.
Big belt.
Now
I know in California courthouses, you're not allowed to take a video camera phone. Like, you're not allowed to take a phone that has a camera on it. Is it the same here?
No, you can take your phone in, but
Just
you just
turn it
have
off.
to turn it off,
Yeah.
put it on vibrate or something.
Okay.
You're not allowed to take any photographs.
No.
And if they catch you doing that, the bailiff is gonna, call you down, yeah.
The only time we take photographs is like at an adoption, and we have permission
Right,
for those.
it's at the end, and
Yes.
it's usually a picture with the
Yes.
judge and the,
Yes.
yeah, so.
All right. Well, thank you very much for coming, Renee.
Sure.
Appreciate it.